Attorney General.
Thank you so much for affording us the opportunity a short while ago, Madam Chair, for the break. I'm looking at Senator Welch's proposals in subsection 1, inserting in writing, yes. In subsection 2, the word also after the word shall. Subsection 2, an interview shall also, right? Yeah, it's agreeable. So that's A and B. And deleting subsection 6, yes, that would make sense. And then the consequential renumbering would happen. There would be an amendment to clause 10, which we probably, subclause 10, which we need to do. May I explain that, Madam Chair? Okay. So, Madam Chair, we are minded to accept, and we thank Senator Welch and Senator Vera, both of whom I've had a chat with at the break as well. We are happy to accept the amendments proposed at clause 12Q by Senator Welch as it relates to paragraph A, paragraph B, and paragraph C. In making those amendments, we've observed that subparagraph 10, which is at page 36 of the bill, bottom of the page, which says, an interviewing officer shall record in the approved form these words, and in the station diary, any interview under this section, and any reason why it is not reasonably practicable to comply with any of the provisions. We believe that the words, any interview under this section ought to be removed. And, up to the word and. And that's because we propose to maintain keeping 12R, which is the register of interviews. Subparagraph 4 tells you where you can't do the video, put it in the station diary, the reasons why. Subparagraph 10 would therefore tell us all of the other reasons why you couldn't comply, which were not caught in the further subsections. So in summary, I'm saying we propose to accept the recommendations of Senator Welch, and then I will propose a further amendment to clause subparagraph 10, which I can pick up in my own amendments proposed to Q.
Amendments to Q, I don't think.
No, I don't. So I can either propose it, I could ask Senator Welch to propose it.
Yes, let's just ask Senator Welch if he'll incorporate a new D in your amendments to delete the words any interview under this section and in subclause 10. Yes? Sure. So
Madam Chair, there's one further.
Okay.
In subparagraph 4 at the top of page 36.
Yes.
In the third line after the word recording, we should insert the words under subsection 2 so that it will read just like that which is in subclause 7. So you see how we have is being made under subsection 2. So where it is not reasonably practicable to record an interview by video recording under subsection 2, the interview, comma, the interviewing officer shall, and it continues. Yes, please.
Yes. I can incorporate that if as part of my amendment.
Yes, please. Thank you.
As well. We're on 12Q.
Yeah. So you want to put the correct language for that, and we put it in.
So, Senator Welch, if I may be allowed to read to you your proposed amendments. At 12Q.
I just interject one matter that has just occurred to me, which is 11 at the top of page 37. I see the recording of an interview under this subsection which was conducted. Subject to section 12R shall be admissible as evidence. I am just wondering why admissibility is subject to subsection 12R. Because it might imply if it is not put in this register, it would not be admissible. And to me, that would be somewhat startling.
Well, in light of the fact that we've gone to writing now, the caution for the need of the register of interviews would disappear. So
yes.
It stands to reason that 11 could go.
Or just say, the recording of an interview under this section shall be admissible as evidence.
It can stay, but
I mean, sorry, that is subject to 7. Sorry, forgive me, I'm being imprecise. The subject to 12R could go.
Yes, under this section, right, subject to, right. So it should just read the recording of an interview under this section shall be admissible as evidence.
Yes, deleting the words which was conducted subject to section 12R. The recording of an interview under this section. Right. That's correct.
So that would be it for 12Q for me.
We now have to record everything that has been
Very well,
amended,
Madam
further
President.
amended, and further amended.
Very well,
okay?
Madam President.
So which was conducted. So, Honourable Senators, please allow me to read the entire 12Q as proposed by Senator Welch. And I really would ask for everyone to pay attention at this stage because it is a little time-consuming to have to go through this.
Yes, ma'am.
So 12Q in subsection 1 by inserting the words in writing after the word record. B in subsection 2 by inserting the word also after the word shall. I think we'll take off and.
Yep.
C in subsection 4 by inserting the words under subsection 2 after the word recording.
Mm-hmm.
D, delete subsection 6.
Yes.
E in subsection 10 by deleting the words any interview under this section and, and, F, delete the words which was conducted subject to section 12R.
That's perfectly correct.
Yeah?
Yes, Madam Chair.
Yes. In subsection, so F will read, in subsection 11, delete the words.
Yes. Which may be conducted subject to.
Honourable Senators, the question is that clause 4 at 12Q be amended and as circulated by Senator Welch and further amended as has just been outlined. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Clause 4 at 12Q, the amendment and further amendments as proposed by Senator Welch, those amendments have been accepted.
Yes, ma'am.
We move on to 12R. Senator Welch, you have an amendment. Attorney General, you have an amendment.
So,
Yes.
Madam Chair,
Yes?
my amendment is to remove the words on request in 12R. I understand from the clause that we've just, the section, the proposed section that we just finished, the rationale as to why Senator Welch was proposing the elimination of 12R.
Yeah.
We would still like to keep the précis, if I could call it that, in the register of interviews in the form set out in 12R. What we do think we need to do in 12R, subsection 2, is to remove this on request. So an interviewee or his representative shall on request be provided with a copy of the entry. We should make it mandatory that they shall be provided with a copy of the entry in relation to his interview, so that there's a record to the defense at the suspect at the same time. I am anticipating Senator Welch's submission in respect of this section 12R, but we prefer to still keep it because we want to harmonize our register so that diaries don't go missing or things don't go missing, and there's still at least a record of it.
Senator Welch?
My recommendation for its removal was that once we have the statement in existence, it would have all these details. But I don't see a difficulty if we continue to have the register, essentially.
So that you will withdraw your amendment?
Yes, I would withdraw my suggestion that it be deleted.
Thank
12R be deleted completely.
And Attorney General, the question is, so we will put your
At the end, yes, ma'am.
amendment at the end.
Yes, please.
Yeah? We move on to 12S, both the Attorney General and Senator Welch. I think you have the same amendment, am I right?
Yes, Madam Chair. May to shall.
Yeah. So, Senator Welch, your amendment is the same as the Attorney General's. Will you withdraw
yes.
yours? Thank you very much. Attorney General, we will proceed with that.
Yes, ma'am.
Yeah? Then we move to 12U.
Sorry, Madam Chair. In light of an amendment that we just took a short while ago,
Yes.
Our team has observed that we do need to make a small amendment to, is it S? Yes, forgive me, Madam Chair. So I would need a further consideration in clause 12S as in Sierra.
Yeah.
And we're looking at subclause 8, QRS, which is on page 41. So at the top of page 41, you'll see subclause 8.
Yeah.
We're proposing to delete all the words occurring after the word replayed. So see that word beginning to? So we're proposing to delete all of those and to insert instead the words reread to the interviewee and reread to the interviewee. Got you? Yeah.
Okay, so Attorney General, if you could just give us some time to record.
Yes, ma'am.
Yeah?
So the amendment in I at my submission would be in proposed section 12S3 by deleting the word may and substituting the word shall. That should be an A.
8.
There should be an A, and then it should be followed by a B,
Yeah?
which would be in subclause 8 in brackets by deleting. So the B should be in subclause 8 in brackets by deleting. In subclause 8 in brackets by deleting all the words occurring after the word, open quotations, replayed, R-E-P-L-A-Y-E-D, close quotations, and inserting the words, open quotations, and read to the interviewee. So that is and read to the interviewee, close quotations, full stop. T2.
So it's 12S, 8.
Let's look at it quick.
In subclause 3 by deleting the word may and substituting the word shall, and B in subclause 8 by deleting the words
Well, you know,
occurring
look,
after the word
I don't even know
repeat.
where I am. I just wrote out everything. Members,
Yes, ma'am.
if we can just treat with 12S. So in the proposed section 12S, A
In subclause 3.
in subclause 3 by deleting the word may and substituting the word shall,
Yes.
and in subclause 8 by deleting all the words occurring after the word replayed and inserting the words and reread to the interviewee.
Yes, Madam Chair.
So that we move on now. Any questions or comments on that proposed amendment? Yes, thank you. So we move on to S.
Madam Chair, it's not on your list, but it flows from that which we have accepted. It is 12T as in tango on page 41. It flows from the amendments that Senator Welch gave us.
Sure.
Yes, Madam Chair.
So, where will we?
You have any extra people? Yes, Madam Chair. So 12T as in tango flows. This would have been where we didn't contemplate the writing of an interview.
Sure.
So 12T1 stands. 12T2
Yes.
at the very last, at the penultimate line. I'll just explain it before I dictate it. Instead of a written record of the remainder of the interview, we put the. So delete a and put the. Just let me give you the language for that now. So it would be in
Remainder of the.
proposed section 12T as in tango. In the 8th line, by deleting the words a written. Yeah. Sorry, by deleting the words make a and substitute the words open quotations, continue taking the. Yes, ma'am? 12T2. Just let me get the lines right. Okay, so 1, 2, 3, 4, 5, 6, 7. In the 7th line, delete the words make a, close quotations, make a, and substitute the words open quotations, continue taking the, close quotations.
So in 12T2, delete the words make a and substitute the words. No, make a and substitute the words continue taking the.
Yes, ma'am.
Yeah?
Thank you. Thanks, Nirana. And
Yeah?
Veronica.
Okay. Any comments on that proposed amendment? Sure, so it's accepted. Thank you very much. So so we've done 12S, 12T. We go now to the proposed amendment, 12U. Senator Welch.
Yes. In light of the fact that the other amendments have been accepted, I think this should now be rephrased to read as I have recommended in the list of amendments, because the present 12U3 speaks of where a transcript of the recording of an interview is made. That is assuming that the bill remained as it is unamended. Where you have a video recording of the interview, then where a transcript of that video recording is made. But if we now have that the interview must also be recorded in writing, then it follows that 3 should be deleted or rephrased to read, where an interview is recorded in writing, the interviewer as representative shall be given a copy of the written interview within 7 days of the recording of the interview. The transcript assumed it was only video recorded, and someone listened to the video recording sometime subsequently and transcribed it. But if we are saying that the written interview has to be recorded at the time, simultaneously with the video being made, then we are talking about providing a copy of the written interview.
Madam Chair, I wonder if it's not two things that we really should be doing, because the transcript, in my view, would be more than what we actually write. So if I use these proceedings here, our circulated amendments could be put into one page, but the transcript of what we're seeing in committee stage is different. It may be more fulsome. So I understand, notwithstanding the amendments made, I understand that the transcript may be broader than the written copy. So there are two things on the table then. The obligation to be provided with the written statement that you gave within a particular time frame, and if they made a transcript of the video of you giving the written statement, that transcript may be different from the written statement, and I would assume that that has to be given as well. Because
I see. Although strictly speaking,
yeah,
one would think that if the written interview is being done verbatim, it should reflect all what is on the video.
yeah.
But if you wish to say, if a transcript is made, and if you wish to maintain transcript and written interview in that section, then I don't see a difficulty.
Do we have any section? Yeah.
Yeah, I agree with you, because what is written in the interview is just coming from one source, but the transcript would also record the interaction by the interrogating officer and what else is
JP,
taking place
everyone
in the room,
else.
which could be useful as well.
Yeah. So
A written interview. The written interview records all sources, questions and answers. That's because if you just record answers and you don't know what the question was.
yes, but you see the bit about that which was observed in brackets, got up and crossed the room, those sorts of things.
I mean, all those things are supposed to be, all
Yeah.
those things are recorded in a written interview.
I see.
In a statement, I can tell you that as a matter of practice in all the interviews I've seen. Break taken, and I think it's in following the judge's rules or the standing orders. Everything is recorded.
Got you. So the question is, well, we do know that the written statement that you give and that you sign, etc., you get a copy of that in your disclosure. The transcript, I thought, and forgive me, I don't practice in the criminal arena, but I thought that the transcript could lend itself to being different in certain circumstances, and I wasn't sure, even though it was relating to something else contemplated, which we've now amended, right? So insofar as there may be a distinction between the transcript of the recording and the written record, which you have signed and you've been given a copy, do you
the only difference is that you're doing one simultaneously and the transcript
in arrears?
It may come afterwards, so it's given a different name. But what the interview itself is a transcript of what's
I understand.
being video recorded.
I don't know how to treat with it. I don't know if we're really differing on anything, quite frankly. So yours says where an interview is recorded in writing, stick a pin, the interviewee or his representative shall be given a copy of the written interview within 7 days of the recording. Is it that?
Right. So it's recorded in writing, and he's given a copy of it. You can also be providing him with the video as well, but that's already catered for.
So the question in my mind is whether you ever leave that station having given a statement without having a copy of it in your hand.
Sorry?
I said the question in my mind is, could there ever be a situation where you've given a written statement and not be given it immediately? You always get it.
The present practice is that you wait until trial and charge and disclosure. But with these provisions, which are contemplating immediate disclosures, then you simply would have to now make a photocopy of it.
Mm-hmm.
And let's say a photocopy of it isn't available right there and then, a photocopier, then the 7 days would apply. But the written interview is really a transcript of what is on the video.
Gotcha. So I've asked that to discern now two concepts. One, being given the statement within 7 days and not at trial, which is an improvement in the fairness of the process, etc. And two, if there's a transcript, which for some reason may be different, I don't know, I'm assuming it could be, that you get that within 7 days. So do we want to amend 3, as proposed by you, where an interview is recorded in writing, that's fine, or transcribed? The interviewee or his representative shall be given a copy of the written interview or transcription of the interview. Do I want to capture 2 things as opposed to 1 is my question?
Oh, okay, very well.
If you just give me a
Although
moment,
I think
Madam Chair.
they're basically the same, but if you want to be complete. If you put it as or.
I understand. I understand, but the
We have anywhere else in here where it says you will be given a written statement, copy of the written statement?
No, because we wasn't talking about statement
No.
before.
So could we say
They were-
So Johnson, going it over, we're going to go and see, the question is, that clauses
it,
trying to get your attention.
situation 80.
apologize.
No. I was wrestling with it because the two things basically are saying the same thing. But the reason I'm inclined to go with Senator Welch's amendment is because really the focus here is not so much on the recording. The focus here is on what is written.
The handing of the thing.
And so by saying where the interview is recorded in writing, which is really the crux of the matter, that is what is handed, rather than the focus being on the transcript of a recording.
So my own position is to capture both. because I don't know in certain circumstances if you may have two totally different things. There may be a habit of transcription. So right now we use mass technology, we give them the video and we have somebody transcribe it, and that is produced. And it will be done with greater rapidity as we go along. I was minded to capture both just in case, because I didn't want them to say, well, you're only entitled to the written statement, and then the prosecution comes to rely upon the video, which shows some inconsistency with the statement as to a nuance that may arise in the trial. I don't know, right? I mean, Senator Welch's experience that he's sharing with us is, look, everything is recorded in that statement, and so you don't need to worry about it. But I don't know how this will evolve. That was just my thought as a legislator coming forward. So I was looking at the same amendment Senator Welch has, and if I read it with my thought in mind, Senator Welch has, where an interview is recorded in writing, I would add here, or a transcript of the recording of an interview is made, the interviewee or his representative shall be given a copy of the written interview or transcript of the recording within 7 days of the recording of the interview, so that I would capture both. It may be superfluous, but I don't know if there's going to be a divergence at some point. I really don't know.
I'm with you. I think better to have than to want.
Is that agreeable, Madam Chair? Could I fashion that?
Yes. If you could just read it now. I think it's inserted some words after interview.
So in clause 12U, as circulated by Senator Welch,
Yes. At sub 3.
at sub 3, in the bold that he has there,
Yeah.
to insert in the appropriate place the following. So where an interview is recorded in writing, or a transcript of the recording of an interview is made, and then it would continue, the interviewee or his representative shall be given a copy of the written interview, or, inserting here, or the transcript of the recording of the interview. And then it continues within 7 days of the recording of the interview.
So it shall read, it is proposed that clause 3, that it be as follows. Where an interview is recorded in writing, insert the words, or a transcript of the recording of an interview is made, comma, the interviewee or his representative shall be given a copy of the written interview or the transcript of the recording of the interview within 7 days of the recording of the interview.
Yes, ma'am. He's cautioning you on the words insert.
You are accepting this as your amendment?
Yes.
Yes? Yes.
You have a question? I see.
Attorney General,
Yes, ma'am.
yeah?
Yes,
So,
please.
Honourable Senators, the question is that clause 4 at 12U be amended as circulated by Senator Welch and further amended as follows by inserting the words after writing or a transcript of the recording of an interview is made, and then inserting the words after interview or the transcript of the recording of the interview.
Perfect.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. We move now to 12X. Both Senator Welch and the Attorney General have proposed amendments. Attorney General?
Yes, Madam Chair, I've accepted Senator Welch's amendment and incorporated it myself in addition to another one which I had proposed.
Yes.
So at 12X, in the chapeau, I had proposed to delete the investigating officer and substitute an investigating officer, which brings us in line with the amendments we made earlier. Right. And then I, in paragraph B, accepted Senator Welch's recommendations in my own words.
Yeah. So Senator Welch, in light of what the Attorney General has said, are you minded to withdraw your amendment?
Yes, in
And
light
let
of
the Attorney
the fact
General
that
go
it's
forward?
been accepted.
Thank you very
Senator.
much.
That is with respect to 12X1C, correct?
Yes.
As it is?
Yes, sir. Let's be sure.
And is there any comment with respect to 12X1A as proposed by the Attorney General?
Yes, it's accepted.
It's accepted? Thank you very much. We move on to 12Y. Attorney General and Senator Welch, you both have amendments.
Yes.
Yes, Madam Chair, consequent upon Senator Welch's contribution, I agree that the word shall, as it's used in 12Y, could be offensive to the separation of powers, and that there ought not to be a circumstance where evidence is automatically accepted by a court, particularly this kind of evidence. And therefore, we propose the amendment of the word, deleting the word shall and inserting instead the word may, so that it is entirely subject to the jurisdiction and discretion of the court as to whether the evidence would be admissible or not.
I see. Madam President, my suggested amendment goes further than that.
Yes.
In that I have suggested that 12Y be deleted completely. And I can explain briefly. The effect of 12Y, when you look at the total provisions of 12Y, is that the video or audio recording of a witness statement, that is the statement given by a witness to the police, shall be admissible as evidence. Now, when you look at the other sections, this contemplates that the witness is a witness who may be available, because 12.3 and 4 speaks of the witness coming to court for cross-examination, etc. So this is not a situation in which the witness is dead or something is wrong with the witness or it's a vulnerable witness, because the later provisions regarding vulnerable witnesses already caters for the receipt of evidence of vulnerable witnesses. This is just a provision which doesn't specify any circumstances, any special circumstances. It simply states that you can put the video recording of a witness statement to the police into evidence. There is nothing to prevent a prosecution in the course of a prosecution from saying, we are relying on Section 12Y, and we are putting this witness police statement into evidence. They do not have to give, under 12Y, they do not have to give any reasons. They do not have to give any circumstances. 12Y just allows it to be done. And the very 12Y contemplates that the witness may be available, because it says the admission of the video or audio recording.
I'm sorry to interrupt, to save you some time. I'm minded to delete the clause, and I'll explain why. At this point, I think I need to go back to the stakeholders on this particular point. My gut feeling tells me that perhaps the stakeholders didn't appreciate the gravity of this clause. I don't think it interrupts with the abolition of preliminary inquiries, because sufficiency hearing versus initial hearing will take care of that. So we're not back to the dance of paper committals and cross-examining, etc., and the fiasco that happened in trying to improve preliminary inquiries. This sort of runs aground in similar form to the Interception of Communication Act, which we amended recently, where we put in special conditions for the admissibility of sensitive information, but we did put in the characteristics for it.
Attorney General, if I may interrupt, we have a procedural issue.
Apologies, yes, ma'am.
Honourable Senators, the Senate will now resume. Leader of Government Business.
Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favour say aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the completion of the business at hand. Honourable Senators, we will now resume the deliberations of the committee.
Yes, Madam Chair. So sorry to have interrupted Senator Welch, but I believe we ought to exercise some caution on this particular clause. I'd not want to go without the special circumstances being identified in better form. I think it is an excellent caution that we stop and take heed of that. So in those circumstances, Madam Chair, I will agree with Senator Welch's proposal for the deletion of 12Y. I'll go back to the stakeholders, look at it, see whether I need to improve with defined circumstances for admissibility, and then reapproach the Senate and House if necessary.
Senator Vera.
AG, just to point out that the Law Association did speak specifically to 12Y. They said it was not clear under what circumstances a statement of testimony of a witness under 12Y may be recorded and then used later on.
Yeah.
And then they also had suggested circumstances in which it could or could not.
Senator Thompson-Nye.
I wanted to know through you, Madam, whether Senator Welch is reading this to mean that it must be admissible, because I'm reading it to mean that it can be admissible. If you say shall be admissible, all you're saying that it can be and the circumstances must be examined, there must be provision for the attorney on the other side to say, you know, I object to this or I don't object to this. It doesn't mean that it must be. In this case, the shall be is not a mandatory shall at all.
Well, let me respond to it by saying, first of all, the word shall is mandatory in nature, and we are dealing with criminal evidence, which criminal statutes are interpreted strictly. Then secondly, even if Honorable Senator Aye's point is valid, I would still request the deletion of it. For one, it doesn't specify the circumstances. Secondly, it contemplates that the witness, that is 12Y3 contemplates that the witness, it shall not be a bar to the same witness, where appropriate, being allowed to come and give direct oral evidence. So 12Y3 contemplates that this is a witness who is available. And then 12.4 also contemplates that it is a witness who is available because it speaks to where his video recorded statement is admissible. The witness can be brought for cross-examination, can be brought to court, but he shall not be cross-examined on anything already adequately addressed in his recording. So this is also a violation of the rights of the accused to cross-examine a witness on something which he has said in his evidence in chief. Because after you submit that recording into evidence, 12.4 is saying, if he deals sufficiently with something in that recording, the court can say you cannot cross-examine him on it. Well, in criminal practice, that is exactly what a defense attorney wants to cross-examine a witness on, the matters which he has dealt with in his evidence in chief. So when 12Y4 says you cannot cross-examine him on something which is in his statement, which has been put in, because he has already adequately dealt with it, that is a violation of criminal practice and the rights of an accused to confront a witness.
agreeing to Senator Welch's proposed amendment?
Yes, ma'am.
If you are, then are you
Withdrawing mine, yes.
yours?
I got cut short of the interruption by Senator Thompson-Aye. And if I could just say, to underwrite, to reinforce what Senator Welch is saying, the special circumstances set out in Section 15C of the Evidence Act would collide with this. And therefore, I must exercise caution in the submission, and I thank Senator Welch for his submission, which I accept. If anything, I'll go back and have a look at the collision between this proposed section and Section 15C of the Act as it stands, and come up with the special circumstances in the context of vulnerable witnesses and special advocates and other creatures which we've just recently introduced in other areas of the law. But I thank Honourable Senator for the submission.
So, well, I don't think we need to go any further. I think the Attorney General has accepted the amendment as proposed. So, Honourable Senators, the question is that Clause 4 at 12Y be amended as circulated by Senator Welch. Those in favour say aye. Those against say no. I think the ayes have it. The amendment has been accepted. We have now, therefore, reached the end of our deliberations on Clause 4. I now have to put the amendments as proposed by the Attorney General, and then I will again put the amendments as proposed by Senator Welch, and then we will put the question on the clause in its entirety. Right. Honourable Senators, the question is that Clause 4 be amended as circulated by the Attorney General and further amended as follows. In the proposed Section 12A, in subclause 4B, by inserting the words after video and by inserting the word of after the word recording. In Clause 12C, by inserting the words by inserting the words one in subparagraph B by what are you showing me? 5(1) in subparagraph B by deleting the word semicolon and substituting the words semicolon or. In sub 2, by inserting the words after the word witness and by deleting the word not and by deleting the word semicolon and substituting the word semicolon. 3, full stop, semicolon, full stop. 3, by deleting subparagraph D. In Clause 12S, A in subclause 3, by deleting the word may and substituting the word shall, and B in subclause 8, by deleting all the words occurring after the word replayed and substituting the words and reread to the interviewee. K in the proposed Section 12T2, by deleting the words make a and substituting the words continue taking the.
And you've noted that I withdrew paragraph F.
Yes.
Yes, Madam Chair.
Yes. Attorney General's amendments as circulated.
Noting his
To
withdrawal.
note that K in 12Y1, the proposed amendment was withdrawn, and with respect to 12G4B, that proposed amendment was also withdrawn.
And with respect to paragraph G, with respect to 12K?
And in respect to 12KA, that was withdrawn, and 12KC was also withdrawn.
Yes, Madam Chair, that's perfectly correct.
Okay? Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question, therefore, is that clause 4 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 4 as amended now stands part of the bill.
Clauses 5 to 12.
The question is that clauses 5 to 12 stand part of the bill. The question is that clauses 5 to 12 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 5 to 12 now stand part of the bill. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate.
Thank you, Madam Chairman. Madam President, I wish to report that a bill entitled An Act to Amend the Evidence Act, Chapter 702, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on a bill entitled An Act to Amend the Evidence Act, Chapter 702. Those in favour say aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be now read a third time and passed.
Senators, the question is that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it.
Mr. Khan?
Yes.
Ms. Gopi Skoon?
Yes.
Mr. Rambarat?
Yes.
Mr. Sinanan?
Yes.
Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. De Freitas?
Yes.
Ms. Cox? Mrs. Sagram Singh Suklal?
Yes.
Mr. Bacchus?
Yes.
Mrs. Lee Singh? Lizama Lee Singh?
Yes.
Ms. Betelmi?
Yes.
Dr. Brown?
Yes.
Mr. Mitchell?
Yes.
Mr. Mark?
No.
Ms. John?
No.
Ms. Lachmidial?
No.
Mr. Nakid?
No.
Mr. Lyda?
No.
Mr. Roberts?
No.
Mr. Richards?
Yes.
Mr. Vieira?
Yes.
Dr. Dial Singh?
Yes.
Ms. Dionarine?
Yes.
Ms. C. Prasad?
Yes.
Mr. Timal?
Yes.
Mrs. Thompson-Nai?
Aye.
Mr. Welch?
Yes.
Mr. Singh. Ms. Cox.
Yes.
Madam President, the results of the division are as follows. 23 senators voted for the motion. 6 senators voted against, and there were no abstentions.
Honorable Senators, the result of the division is as follows. 23 senators voted in favor, 6 voted against, and no one abstained. The bill has therefore been passed.
A bill entitled An Act to Amend the Evidence Act, Chapter 702.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 26th of January, 2021 at 1:30 p.m. That is Private Members' Day. And we plan to continue the debate on the motion raised by Senator Vera on the service commissions.
Honorable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Mark.
Thank you, Madam President. Madam President, tax avoidance in this country, particularly in the energy sector, is real. And the whole issue of transfer pricing is a mechanism that has been used by the energy companies to avoid taxes and to prevent Trinidad and Tobago from getting its fair share. This, of course, was manifested when the government held its spotlight on energy in 2018. And the Potent and Partners consultancy revealed in its report that 2 major energy companies had denied this country of revenues amounting to over $15 billion over a period of about 7 to 8 years. Now, Madam President, this was reflected in the gas master plan. This revenue could have been used in a very powerful way to help stabilize this economy. And the government gave the impression that they were committed to addressing this matter. Madam President, the Petroleum Taxes Act dictated that the government address this issue. The company involved, obviously, Shell and BP, told this country that essentially a contract trumped the law. And the law in question was the Petroleum Taxes Act, along with its regulations. This situation, Madam President, turned out to be very wrong. It was not in favor of the country. And the government has not been able to properly explain to the citizens why it had foregone some 15 billion US dollars that were owed to us. We understand that the government simply caved in to these giants when they were told that the contract is what was guiding them. But, Madam President, the question has to be asked, which is more superior, the contract or the Petroleum Taxes Act and its accompanying regulations? And what authority did the Minister of Energy and the Prime Minister have in bypassing in their negotiations the law that govern this very important matter? So, Madam President, we are calling on the government to explain to this country, because all we got in return was $1 billion when we were supposed to be getting $15 billion. That is over $100 billion, Madam President. Had that money been extracted from these energy giants and put in a fund at a rate of 7% interest, we would have been extracting US 105 million US per year, which would have been able to deal with GATE as an issue, Madam President. That money could have gone into the Heritage and Stabilization Fund. So we need the government to explain to this country why it backed down on really looking after the interests of our nation in this matter. They had a responsibility. There was a report, Portland and Partners, indicating what they had to do. Why did the government refuse to follow the advice of Portland and Partners? And why they allow both Shell and BP to mamagai and fool them at the expense of this country? Imagine, Madam President, I read in the newspapers then where the Prime Minister said that he was literally buffed by an unnamed foreign energy company simply for giving an account and providing information to the country as it relates to this matter, accusing this country and its government of a breach of confidentiality. Madam President, the Petroleum Taxes Act and its regulations require all parties in the energy sector, oil and gas, to be licensed. And the minister under the law is required to keep a register of all these licenses. The ministry obviously has not been in compliance with this law because that is not available to the public. Madam President, what happened is that the government proceeded, as I close, to provide these companies with an extension of their license agreement, when the government should have gotten much more from those licenses that were expired, both in terms of Shell and BP. It is in the budget statement of 2021. So, Madam President, I think the time has come for the government to level with the country. Why did we sell out the national patrimony for $1 billion when we were supposed to be entitled under the law to enjoy 15 billion US dollars and above? This came about, as I said, Madam President, because of transfer pricing and tax avoidance. This government promised Trinidad and Tobago that it will introduce legislation on transfer pricing. That was since in 2016, 2017. We are now in 2021, and we are still awaiting transfer pricing. And these companies continue to do their own thing at the expense of Trinidad and Tobago. It's against this background that the people are calling for answers. They want the government to come clean, and they want the government to tell us, why did we forego $15 billion in exchange for $1 billion? And why did they proceed to extend these licenses, which came to an end, which we could have taken and really reorganize and maybe lease for much more than $1 billion. And in one instance, Madam President, I read where it was $250 million. So this is a matter that I think that we need to clarify, and we need to get answers once and for all from the government. So I would like the Honorable Minister to clear the air and see what Trinidad and Tobago can do at this 11th hour to extract our monies that we have lost as a result of their bad deals. Thank you very much, Madam President.
Minister of Energy and Energy Industry.
Thank you very much, Madam President. Madam President, the UNC missing Kevin Ramnarine. Because even though he is not my favorite, he's my opponent. At least he had some semblance and knowledge of this sector. As we speak, with all due respect to everybody here, the UNC has no individual, neither in the upper house nor in the lower house, who is seized of energy matters. I mean no offense to anybody. This is a complex global industry. Senator Mark is right. Putin and partners did identify serious revenue leakage. But what he didn't say, that the $15 billion, and I'll show you how Putin calculated that, was leaked from this economy over the years 2011 to 2014. The hemorrhage took place under the watch of the United National Congress. You all didn't even know. You all took no cognizance of that. You all were asleep. Because in that period, there's something called the Standing Committee of Energy, which is chaired by the Prime Minister. For 5 years, that committee did not meet. It was chaired by... No, sorry for that. For 5 years, the Prime Minister didn't attend a single meeting as chairman. It was chaired by Larry Hawaii, with the help of Kevin Ramnarine. And it was the one eye leading the blind. So, what Putin said is that, before we go to Putin, when Atlantic LNG was constructed, it was a major, significant capital investment in this country. Trinidad was the third country in the world that went into LNG. The first was Indonesia, the second was Qatar, and the third was Trinidad. It was a major, major policy shift. When Train 4 was finished construction, Train 4 was the single largest LNG train in the world. That was significant capital investment. And when capital investment of that size is taken, it must be justified with long-term contracts. So the long-term contracts in those days were based, there was a time when the plants were young. All our LNG was exported to Boston. We supplied 80% of the LNG market in the United States. Prices were high then. And what happened is that the long-term gas contracts was based on Henry Hub, which is the US benchmark. However, over time, the market changed. There are other markets. There's Henry Hub. There's JKM, which is the Japan-Korea market, which is now the lucrative market in the world. There's NBP, which is the European market. And there's a pricing formula based on Brent crude. So with a global shift in prices, Henry Hub prices became low. The lucrative market was China, was Korea, was Japan. All Poten did was saying that if our LNG was exported to those countries, we would have been making significantly more revenue than we were. But we were locked into contracts based on Henry Hub reference prices. However, there was evidence that there was cargo switching out in the open Atlantic because these companies have global portfolios. But the natural gas is not fingerprinted. You can switch anywhere. It's not to say Trinidad natural gas has a special color. LNG is LNG. So what Poten analyzed and said, if these contracts were changed, and if these contracts were based on a basket of markets, we would be able to extract more money. But all that hemorrhaging took place under the UNC. It is when we came into office, we went back and renegotiated those contracts. And these contracts wasn't due to expire. When we met at the headquarters of BP and Shell, these companies said, we understand that Trinidad is not getting its fair share of its LNG. But we want to make one thing fundamentally clear. We broke no law, and we breached no contract. But we are willing to sit and talk. And that was the basis of negotiation manos manos, led by the Prime Minister, including myself and Minister Young, and a party of technocrats from the Ministry of Energy. And then we worked out what was called the Train 1 reference price, which is 1/3 JKM, which is Japan, Korea, 1/3 NBP, which is Europe, and 1/3 Brent. So you spread your risk, because one day the Japan market might fall. And the very said Henry Hub we're looking down at today may go back up, and vice versa. It's just as when you traded in foreign currency. You spread your risk over a basket of currencies. You cannot take chances with one. So it makes no sense in saying you have a bad deal in a long-term contract because the markets change. So the key points to note here, Madam President, is that the hemorrhaging took place. But it took place because of long-term gas contracts that was signed when the plant was now built. Most of the hemorrhaging took place under the watch of the United National Congress. And it is this administration, under Dr. Rowley, and this current, if I say so myself, the Minister of Energy, that went in and renegotiated these contracts with Shell and with BP, so that today we are on a firmer footing. However, the revenue is not lucrative, not because of the contract, but because of the global price. In those days, LNG was selling in Japan at $13 US per MMBTU. Right now, Henry Hub is $2.55. And even Japan and thing is just above $3. Only recently it had a spike. So while we have revised the formulae, the market has dropped. But when the market picks back up post-COVID, Trinidad and Tobago will be in a much better state. But to come here now and claim that we did anything wrong, far from the truth. It is we who have made the wrong right. And it is under the United National Congress that this country was virtually ripped off of billions of US dollars because they had poor oversight. They didn't have a watchful eye on the energy sector. And for some strange reason, they went asleep on the job. That is why today they are there and we are here. Thank you, Madam President.
Senator Mark?
Madam President, in the 2021 budget, the government announced the deregulation and liberalization of the fuel market. That is, gasoline prices, diesel, premium, super, according to the government, will now be deregulated and liberalized. And that is supposed to take effect from the end of January of 2021. The minister needs to bring us up to speed with where we are with that particular policy decision. Madam President, after some 46 years of fuel subsidies, because of we being owners of oil and gas, that is the people of this country, this PNM government has decided to remove fuel subsidies and allow the market, literally, to determine the price of fuel. So what the government has said, in essence, is that there will no longer be a fuel subsidy. Now, Madam President, we know that there is a subsidy on crude oil production, and companies are supposed to be making a contribution to the ministry and to this country towards this particular subsidy. The question that has to be asked is that with the removal of the fuel subsidy, what will happen to the subsidy that the oil companies have contributed to that particular subsidy that allowed the country and the people to pay lower prices at times for the price of fuel, whether it's diesel, whether it be super or premium. Will the government allow the oil companies to go free and allow them to accumulate higher profits? Is the government going to repeal the appropriate legislation so that the oil companies that normally would pay and contribute, would they now be retaining that particular subsidy? This is an issue that the government needs to clear up. Madam President, I am asking the Honorable Minister whether the time has not come to place that subsidy, that particular subsidy that was on crude oil companies or companies that were producing crude oil, whether that now should not go to companies that are producing, Madam President, gas. Should we not impose a subsidy on the gas producers, particularly those who are now getting higher gas prices, the upstreamers as they are called, and putting the NGC and the whole Point Lisa's industrial estate in jeopardy? Whether the time has not come for that to take place. Because, Madam President, if that does not happen, what is going to take place is that the government has already served notice that the RIC is going to move post haste in 2021 in order to increase electricity prices. If the government was creative, they would have transferred that subsidy onto the gas upstreamers. Let them subsidize the population, because that is our natural gas that they are using, they are selling, and directly exporting. So I have raised this matter to get from the government what steps are being taken to cushion not only gasoline prices that will increase as the economy on a global scale rebound. So when prices increase, Madam President, on the international market, with the deregulation of gasoline sales and the retail outlets, as was indicated, through gas stations, the privatization of gas stations, Madam President, the population will be called upon to pay higher fuel prices. And our buffer that was there before, the government has served notice that it is going to remove that buffer. So no longer are we going to be getting that subsidy that we traditionally enjoyed for over 46 years, according to the Minister of Finance. So, Madam President, I have raised this issue to get from the Minister, to secure from the Minister, what measures are going to be put in place to ensure that the population of this country in this period of COVID and this economic crisis that we are going through, how are we going to provide them with some degree of a buffer in order to withstand these prices that inevitably will increase? So the government is removing, as I said, subsidy on crude oil. And in doing that, the government is going to punish the people with higher fuel prices in the future. So the question has to be asked, why not place the same subsidy on the natural gas producers? Madam President, it is a fact that the government went to Houston, they renegotiated natural gas prices, and those prices have now been in favor of the upstreamers at the expense of the downstreamers. So they are living high and nice, whilst we in Trinidad and Tobago are experiencing grave challenges at the level of the Point Lisas industrial estate, to be translated, Madam President, into higher prices in the coming period, not only for fuel, but also for electricity. So, Madam President, this is a case of energy insecurity because of the sellout of this government of Petrotrin, and we no longer have energy security. It is now back to the plantation under this PNM government, where we are now exporters of raw materials and no longer a producer of refined products, whether it's gasoline, premium, diesel, or super, whether it's aviation. All of these fuels, Madam President, now have to be purchased abroad. And Madam President, to add insult to injury, the government has given, or has leased, I should say, I understand, and the Minister can correct me if I'm wrong, some 600 acres of land at Brechin Castle. This land has been given to establish what is called a solar farm, and it comes under the name of Light Source. And the owners of Light Source, again, BP and Shell. So they, Madam President, are supposed to be producing electricity, Madam President, and they are going to be selling that to, obviously, the national grid. And that, again, Madam President, is going to be it will bring about a negative impact on our country. Now, we know about the new energy thrust and the green economy. So, Madam President, we understand this solar project is expected to produce 92 megawatts. I am calling on the Minister to clarify these matters and to tell us, Madam President, in closing, what steps are being taken to address the interests of the people in the face of the removal of subsidies on fuel in Trinidad and Tobago, Madam President.
Of Energy and Energy Industries.
Let me take a deep breath, Madam President. Madam President, the last time Minister Imbut piloted a bill here, Senator Mark said you have Panadol in his pocket because you want to give him a headache. Well, Senator Mark, lend me the Panadol, please, because I'm really getting a headache. The lack of understanding in some of these matters is bizarre. Let me start from the beginning. I take your mind back, for those of you who are old enough, to 1974. Oil price was $6 a barrel. And then there's something called the Arab oil embargo. The formation of OPEC. And within 6 to 8 months, oil price jumped to $36 a barrel, which is about a 5 or 6-fold increase in less than a year. By the time it was 1977, Trinidad and Tobago was producing its highest crude oil production in its history, which is 270,000 barrels a day, largely coming from the Puitik and Saman fields. The phenomenal increase in the price of oil obviously would have led to a significant increase in fuel prices. Dr. Williams, in his wisdom then, introduced something called the Petroleum Production Levy and Subsidy Act, which took from the oil companies, not gas, oil, because it's fuel you're going to subsidize, 4% of gross revenue to subsidize the fuel to the local market. That went on well. However, as production fell, so 4% of 260,000 barrels is significantly different to 4% on 100,000 barrels. So as production continued to slide through time and oil prices keep climbing, they reached a stage where the curves crossed. So much so that when oil prices had reached $100 and $90 and what have you, over the last 14 years, the government has had to subsidize fuel prices to the tune of $25 billion. This subsidy is in addition to the sometimes 400 million, 500 million coming from the petroleum subsidy levy. But it reached a stage where the levy was small compared to the size of the subsidy. And that was the reason why government has to subsidize that in such a significant way. Where did the revenue come to subsidize that? Gas. It wasn't a direct taxation on gas to subsidize it, but it came from the gas industry. So we've reached a stage where we cannot support the subsidy anymore. And to speak about gas, when this administration imposed the royalty on natural gas of 12.5%, Madam President, I've said this here so many times, and I'll repeat it again today. The royalty on natural gas was 1.7 TT cents per MMBTU. We imposed a 12.5% royalty on gross revenue from gas, from natural gas. Today, as I speak, the largest single source of revenue that this country earns is coming from the gas royalty of 12.5%. That was revenue that was foregone for years by former administrations. So we're in a position now where we have reduced the subsidy, and we have, with the liberalization, we are going to have zero subsidy on liquid fuels. Senator Mark raised a good point. What will happen to the petroleum levy, which is the 4% that is based on oil production from the oil company? Because the Petroleum Levy Act says the levy should cover the subsidy of 4% of gross revenue, whichever is less. So if 4% of gross revenue is more than the subsidy, you pay the subsidy. If the subsidy is more, you pay the 4%. So if there is no subsidy, what will you use the petroleum levy for? Well, Senator Mark, for years, we have been subsidizing LPG. And who bore the brunt of that subsidy was not the state, was Petrotrin. That is one part of where I have a soft spot for Petrotrin. Because for decades, Petrotrin was, by law, was supposed to sell LPG at the price of 37 cents per pound, whereas the international market price is 96, 97 a dollar. Reference to a place called Mont Belvieu in the Gulf Coast. That subsidy was borne solely by Petrotrin. When the refinery was shut down, NP now had to source LPG on the open market from PPGPL because they make propane, taking the liquids from the natural gas stream. But they sell at international prices, Mont Belvieu. That subsidy accounts for over $200 million a year. Quietly, nobody says anything about it. But everybody knows you can get a 20-pound cylinder of propane for $20 plus transport. That same 20-pound cylinder in Jamaica sells for the equivalent of $100 TT. And Trinidadians have grown accustomed to that. So what we have done now, and the revision of the legislation will come to the Parliament in about 2 weeks, we will now be calculating the price of LPG, reference to the international market price of Mont Belvieu. And that now, we will still continue to sell it at $20 per cylinder. But the difference will now be classified as a subsidy, and that money will be taken from the petroleum levy. And our calculations show that the petroleum levy will on about cover it. So the petroleum levy will not go to waste with the liberalization of the liquid fuels market. So we know what we are doing, you know, but we are weaning the nation out of the dependency syndrome. The energy sector is not generating the lucrative surpluses that we have grown accustomed to. And lucrative surpluses are a function of two things, production and price. We are hurting on the production side. Production has been dropping because we are not finding new reserves at the rate in which we should find it, because you have to invest to find. You have to have good geologists to look and know where to find it. You have to have good technology. You have to have good seismic. And you have to have companies with the capital to invest. And on the price side, the international market determines the price. We are price takers. People behave as if we set the price of oil, and we set the price of LNG, and we set the price of ammonia, and we set the price of methanol. Nothing could be further from the truth. We are at the mercy of the market. And this administration has been using all its strength, all its wisdom, all its tact, and all its international connection to keep this energy industry afloat, to keep the economy afloat. And we, in spite of all the restrictions, I think we have been doing a good job. So, the fuel market will be liberalized within a month's time. We'll get to the end of the subsidy line. The surplus that is be generated in the petroleum levy will be used to subsidize LPG. So we are in a net even position, and the country would not be hurt in any significant way from these new measures. I thank you, Madam President.
Honourable Senators, the question is that this Senate will now adjourn to Tuesday, the 26th of January, 2021 at 1:30 p.m. Those in favour say aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, the 26th of January, 2021 at 1:30 p.m.